executive secretary to the president got it right, because now the speaker says he's also learning from them,
Yes.
and has thus decided that they cannot consider the approval of nominees for various positions by the president. This morning, like I indicated, we want to learn more about this. We want to understand what the position of the law is. And Martin Kpebu is a private legal practitioner. He's joined us. Martin Kpebu, good morning. Thank you very much for joining us.
Good morning, Winston. Morning.
Great, Martin. I'll get to you shortly, but first let me introduce our parliamentary correspondent, Kweku Asante, who's also in studio with us. Kweku, good morning.
Good morning, Winston.
Kweku, so tell us what happened in Parliament. I mean, we've listened to the Speaker, we've heard from the Minority Leader, we've heard from the Majority Leader, but you were in Parliament. Tell us what really happened leading to all of these.
So, Winston, this had been coming. In fact, yesterday in the afternoon, we picked signals that something of this sort was going to happen, because the Speaker of Parliament, Alban Bagbin, had been in the US for like a week now. He had not been in the House. The deputies had been presiding. And on the back of that letter from the Executive Secretary to the President, we understood that the Speaker of Parliament was not happy and he wanted to do something about it. And so yesterday he arrived in the country very early in the morning and asked that he wanted to preside on the key part of Parliament leading to adjournment. And so about 2 o'clock, as about 2 p.m. yesterday, the House had to suspend and wait for him. So for about 4 hours, the House was not sitting, waiting for the Speaker to come in and then lead the House to conclude business. In fact, normally when the House is about to proceed on adjournment for Christmas, for Easter, or for whatever, the Speaker will have a closing remarks. The leaders on both sides will also have same. So we expected something of the sort, but we knew there was something big coming. So when he took his chair, he zoomed right into the conversation, addressing a very lengthy statement at the President and his Executive Secretary. In fact, he described their conduct as contemptuous of Parliament, as to whether or not he'll be taking on Nabedi Etu Asante for contempt of Parliament. We do not know yet. But for over 60 paragraphs of the very lengthy one, he really tore into shreds the President's position that because of an injunction application that had been filed by Richard Sky against the Anti-LGBTQ bill, the President says he's not even able to receive the anti-gay bill, let alone signal his intention to sign it or not sign it. And you know that the other case having to do with Dr. Mando Doi has actually been disposed of by the court early on. The court had decided that it will not injunct Parliament in the doing of its work. They did not believe at the time that a case had been made, a prima facie case had been made to warrant the use of the court jurisdiction on that matter. So the Speaker of Parliament did all that, and then just when he was about to end, he catch all of us by surprise by saying that he had actually just also been served by an injunction application filed by NDC MP for Saudai, Roxanne Nelson Defemepo, on the ministerial nominees. We know that the President reassigned some ministers, but Eugenia Haynes put out a letter and said that the President had revoked the appointment, and then in the same letter he said those persons had been reassigned. Roxanne Nelson Defemepo says, if you revoke the appointment of a minister, you must necessarily bring him back to Parliament to come and face vetting committee. The majority had explained that this was just English semantics and that the President was clear in his mind that he had just transferred those persons. Roxanne Nelson Defemepo will have none of that. He had gone to the Supreme Court and filed also for application for interlocutory injunction. The Speaker says, I've been served with that, and because of that, I'm going by the same principle that he had actually disagreed with and said that it was not a good law. But it says if the President said that is the new principle, he's going to abide by that also. And over 22 of President Akufo-Addo's ministerial nominees will all now be approved. As of now, we don't have a substantive minister at the Information Ministry. We don't even have a substantive deputy minister because the minister has been reassigned to Works and Housing. The deputy appointment as a deputy minister has been revoked and promoted to Minister of State, and she has been vetted. She has not now been approved. How is she going to act and all that? So yesterday, the Speaker caught everyone by surprise. The key government business that were all going to be done, the Speaker of Parliament will not listen to anybody.
What were these key government business?
In fact, there were loans, $150 million, that is said to be coming to support the 2024 budget. It's been touted as so crucial to stabilizing the current exchange rate. In fact, yesterday, while the House was on an adjournment, the Minister of Finance was in Parliament negotiating with the Finance Committee how to present their report. Also, tax waivers coming in. We know that KT Amon has been chasing it. Yesterday, he was going up and down, trying to get Kweku Kwarteng to invite members of the Finance Committee to sit on that report. Kweku Kwarteng had given an indication that he was not going to do that. And in fact, my sources were telling me that the government side were trying to get the vice chairman of the finance committee, Patrick Boama, to get a committee to meet and work on that. There were also a number of key papers that have to be laid ahead of Parliament coming next meeting. If you've not laid them now, you can't work on them when you come. And then there are bills. There are so many crucial bills that government hopes they can get it out of the way, because next meeting is rather short. After that meeting, Parliament is literally gone comatose ahead of the election. They will not come and sit again. They will come in November for 4 days, and then they will again sign that until January 2025 when they come and swear in new members. So the government side racing against time to pass some bills, do some key business, because if you don't do them now and Parliament expires, all those business also expires with the Parliament, and you have to start them afresh in 2025. So government wants to avoid that. And so the Speaker of Parliament reads his lengthy address, bangs the gavel and says, I've adjourned the House. Not listening to anybody. The majority side clearly were shocked. They thought after the Speaker had disagreed with the President and said all the things he wanted to say, they would be given an opportunity to react. In fact, the majority leader, it appeared, had written an address that he wanted to read on the floor. The minority leader as well. And the Speaker of Parliament just bangs the gavel and walks away. And then the minority does a news conference, clearly backing the Speaker of Parliament, saying that if the new principle that the President has laid is anything to go by, that is the same thing that they are also going to hold the President for. The new standard now in Parliament, according to the Speaker and the minority, is that if any government business comes to the floor and anybody goes to court and files an injunction application, Parliament will not consider that. And so that is the new principle that the Speaker said is going to hold in Parliament until the President have a rethink on the anti-LGBTQ bill and probably acts on that. So the majority side also does a news conference disagreeing with the Speaker, and now we are learning that if you look at the standing orders, it gives room that 25% of MPs may recall Parliament to come and do business. So the majority side urgently looking at that option to see if after Easter, right after Easter, they can get at least 40 MPs to sign on, and they have it because they have 137 MPs to be able to come back to the House to come and transact those business. As to whether or not, if the Speaker of Parliament calls that meeting, he will even allow them to do any business, is something that we would have to see in the future. But it's really the executive and the legislature now on a collision course Wednesday.
Great, Kpebu. Stay with me. Let me get onto the line now and speak to Martin Kpebu, who's a legal practitioner. So, Martin, I want us to understand the position of the law first of all. We've seen the letter from the executive secretary to the president indicating that because there's an application for injunction against the president assenting to this bill, even Parliament should not transmit it to the president legally. Is that right?
Yes, on the face of it, there is a number of decisions that say that once a person has been served with an application for injunction, that person should cease and desist from continuing with that conduct or action that is intended to be injuncted. So, if Parliament was in the process of transmitting the bill to the president, yes, then that's a conduct that the injunction or the application seeks to stop. So stop it anyway. Wait for the court to go into the matter. Then afterwards, if you win, you may continue. But for instance, so a very popular decision on that principle is called Republic versus High Court, ex parte Moffat. Yes, so it's a very popular case, and it's even cited in the recent Benjamin Dufour versus Bank of Ghana case. So that's one. You won't get quite a significant number of lawyers disagreeing. No, because naturally you will never find all lawyers agreeing. You will find somebody who will come and say he doesn't agree. But I'm talking from a practitioner's perspective. You ask any lawyer who has been going to the court for a reasonable number of years. They ask, "Master, have you been served with an injunction?" Says yes. Can you continue notwithstanding the pendency of the application? You will get a resounding no. Just wait. Wait it out till the court is done. Except there's been instances where when there are sensitive government projects involved, then you see that they try to say, well, the state will melt, etc., national security, then you would find people trying to say continue. But that is not law. The proper thing is, if you think the seat is going to melt or anything, then you would apply for abridgment of time so that the court will deal with the matter quickly. But you are not allowed once you've received an application for injunction, Winston. And no matter how bogus it appears, look, it can have so many typographical errors, not the best of English, all right, etc. But as long as it is an application that the court is here to deal with, it doesn't lie within the other party's map to say that, oh, this application is so bad, it doesn't cut master, so I'll just ignore it. No. Otherwise, there will be chaos.
But Martin, I mean, talking about the application, so we get that point. But the Attorney General advises that the president doesn't assent pending the determination of these cases. The Attorney General did not say that the bill be not transmitted to the executive or to the president. So in this case, can't the bill be transmitted, for instance, while we wait for the determination of the case before the president assents?
Listen, to be very candid with you, I don't think so. Listen, there's a matter in court. Just wait. Yes, because it's against the spirit. It's not just the signing. Anything that has to do with the signing as well. Once you've been served that this conduct, the bill that has been passed, it's unconstitutional, etc., just wait. So for me, to be very honest, I don't support the president that much, but for me to tell you that after this conduct is kosher, then it tells you that really it is. I mean, you've been served, just wait. So I really don't think that saying the bill should not be transmitted is offensive as such. No. Except, of course, some of the words that were used. So if they are complaining about the use choice of words, that's a different argument altogether. But when it comes to the substance of the matter, which is that don't sign pending the determination of the application by the Supreme Court, that one very clear. The president is right not to sign pending the determination of the application.
In that same light, is the Speaker right in not approving the ministers?
Absolutely. Absolutely. It's the same principle. Yes. So the same by parity of reasoning. So my understanding is that Roxanne Nelson Dafia McCoy is filed a suit. I've seen the actual suit. I've not seen I've seen the rate. That's what I mean with the actual, the rate, the substantive rate. I've not seen the application for injunction. But the Speaker says he's been served. So once he's been served, the same principle, ex parte move part. And Winston, I can tell you, 1,000 times, that you won't be wrong based on ex parte move part. You say, look, I've been served with the application. I'm holding my hand. You are within law. You are within law. Earlier on, maybe I hope I'm not running ahead of myself.
Go ahead.
You referred to the Welford faculty. So this is the context. It is when the application has been determined or is being determined, then that's when the merits come in. But the principle is that no matter how bogus it is, you see, you can get an application. You see that this one is really bogus. But as part of due process, you hold your hands. You are not the judge. Go to court and deal with it. But you can't look at the application and say that it will fail. So because it will fail, I will just go ahead and do what I want. That will be contempt. And see, the contempt powers are very wide. And even we add that even in the absence of an application, if you do anything, that eviscerates the case. Like you take the substance out, what you've done, you just make the case itself useless. Let's use the Ghanaian balance. Meaning that, so let's take a typical example. This particular one, assuming that the president is going to sign or not sign. Even assuming they hadn't filed an application for injunction, but they had just filed a writ saying that this particular anti-LGBTQI bill don't sign it, and there's no application for injunction. If you are using true principles of law, the principle that don't do anything to stultify the administration of justice, you have to wait. Because
Martin, if you could kindly reposition yourself, we seem to be losing you, and if you have your radio on, you can kindly switch it off for us.
Let me see. Radius of.
Okay. Then can you reposition yourself?
Moving vehicle.
I think it's better now.
Okay. Yes. So I was making the point that once the conduct that is the subject matter of the suit is such that if you do anything, you've run ahead of the court, you have to stop, even if there's no application. So there's a general principle of contempt that don't do anything that stultifies the administration of justice. So I was making the point that even this anti-LGBTQ bill, in the absence of the pending application for injunction, any day I would have advised the president not to sign, because that is the crux of the matter before the court. Don't do anything that renders the court processes everything ahead nugatory, useless. No. So you don't always need an application for injunction. Winston, that's the point I'm making.
Okay.
You don't always need it. Look, sometimes you just look at the case itself. You look at the merits and you see that, no, this conduct, if I do conduct X, it just goes against the letter and spirit of the whole lawsuit. So I won't do it. Because if you go ahead, you can be convicted on contempt. Yes. Okay. And that principle has always been there. Let me quickly recount. It was used to convict Krobeduse in Kwame Nkrumah's time. It was used to convict S. Dombo. Dombo was Minister for Interior under Buzier's regime. He was also convicted, right? So don't always say that, oh, there's no application for injunction, I can just go ahead. No. In recent times, it looks like there's a certain brinkmanship in government when it comes to certain. It didn't start with this administration. Okay, yeah, it's been, brewing for some time now. There's a certain brinkmanship. They look at the conduct and say, oh, this one, if we stop, the nation is going to melt, so go ahead. Like you see the e-levy thing.
Yes.
It turned out that it was a ruse. The nation wasn't going to melt, right? Those type of things. This is not the only time. But look at a classical example where the president didn't do anything, didn't run ahead of the Supreme Court. In the previous administration, when Kweku Asare filed against the Constitutional Review Commission's work, look, that was a suit that when I read it, it was very clear to me that no, this case will not fly. I knew that no, it won't fly from what I had read. I'm sure lots of lawyers also knew. But the thing was that the matter is in court. He didn't apply for injunction, and no injunction was granted. But the ex-president stayed his hands. I think that was JM. JM stayed his hands until the matter ran its course. And by the time it was done, we didn't, so many other reasons, we didn't get our much wanted constitutional review, something that we're all very passionate about. Yet one lawsuit stopped us, and there was no application or order for injunction. Yet the president stopped. So that's a practical example that you don't always need an application for injunction. But where there is one, hey, Master, don't try it at all to ignore it.
But Martin, so we've seen what's happened in Parliament. What happened in Parliament yesterday? Isn't this thing being abused now? Because all of a sudden you've seen, somebody go to court and say, well, you also cannot do this because we are learning from what you say, okay, that's the law. But now the president has said, this is what I'm going to do. It didn't do in the past. Isn't this subject to abuse? And wouldn't this affect, for instance, even our democratic processes? Because now anybody can just choose to go to court and apply for an injunction and as a result prevent you from doing what you are constitutionally mandated to do.
No, I don't see it in terms of, I don't see it causing so much harm if you take a long-term view. Immediately, it can stultify or disrupt matters for a day or two, but not any longer. You know why? Let's say the application that the speaker talks about, it's within the powers of the defendants, right? The Attorney General and the speaker, or even the defendants in the case, to apply for what we call abridgment of time. Yeah, and there's the Supreme Court has held in a number of cases. They can abridge the time quickly. So if it's that very urgent, they will abridge it and say, come on. And there's been a number of cases that they've used abridgment of time and dealt with expeditiously. So as long as we have those powers in the court, well, there may be a bit of a delay, but not long-term as such. Or, it won't probably cause too much damage. A day or two or maybe a week, yes, we may lose. But there are enough
Yes, but Martin,
law.
so let's say the Attorney General calls for an abridgment of term. Then I also file another application.
Okay. Yes. So now the Supreme Court can give an order showing the way forward for subsequent applications. They did that in the 2016 election. Remember the Nana Kunedu's rate?
Yes.
Nana Kunedu's case in the Supreme Court.
Yes.
Right?
2016.
No, it's Indum. I think it was Indum.
It was Indum.
Yes.
Indum. Yes, he was represented by
Indum,
IPOB.
yes. And then Kunedu was in the line, also preparing to go or something like that. And then there were other presidential candidates who had grievances. Yeah, so the Supreme Court saw all those ones coming and gave an order that for the same reason, all the subsequent applications or those who intended to come, they should all abide by the ruling. So the Supreme Court opened the door for all of them. So in the same way, if the court is giving enough evidence that now people are aware that, if you just file an application, no matter how frivolous, the rule is that wait till the court deals with it. People who abuse the process, the Supreme Court knows how to deal with it.
Well, talking about the Supreme Court knows how to deal with it, there are also, so you've talked about this particular case. Yes, in this particular case, the court ruled and gave all of them a chance. But you lawyers also have a nice way of going about things. You look at the gaps and then come back again. The question is, wouldn't this in the long term affect, because Speaker Bagbin makes a reference to Justice Databan's point in Welford Kwaku case, where it says if it's going to affect the job of state institutions, that cannot be done.
Yes, so that was a previous decision.
Yes.
And the court's decision was based on the facts of that case. Okay? The facts of that case. So they will tell you that no two decisions are the same. If you ask me, currently, this situation we have, the anti-LGBTQ law, the narrative, it's not my understanding that Ghana is about to dissolve, Ghana is about to descend into chaos because the anti-LGBTQ bill has not been signed. I've not seen such evidence. And you remember even 2 years ago or so, the E-Leviton were deceived. It turned out to be a ruse. So it's based on the evidence. So this particular one, I don't see any imminent danger that Ghana is about to be blown out or blown off the whole country. We are all just, going to disappear. No, there isn't that danger. And then you ask about the second one, the one that Fiamepo filed. Oh, that one, Winston, I can tell you that I'm happy that the Speaker has applied the same principle so that these ministers will not be approved. This government is over-bloated. They are wasting too much public funds. So it's good that in the interim, these guys won't come. And if I had my way, another fact, if we can hold them off for the rest of the time of this administration, it's something I'll support any day. Because this government is too bloated. Too bloated. They're spending our money left, right, center, and we don't seem to have much power to do something about it. So This is good riddance, right?
But yes, Martin, someone just sent me a message that says, if I bring an injunction against the EC on 6th December against holding the election, what happens?
So you see, earlier on I mentioned that when there are certain sensitive government projects, then you can look at it and see that this one, if we don't, there's going to be too much trouble, national security, etc. So sometimes people ignore, but it's not the right thing. If you bring the injunction against the EC on the 5th, as I stated earlier, if you want to use proper law, the right thing will be for the EC to apply for abridgment. And so throughout the 9th, the sitting can be conducted. The Martin Kpebu number 4 versus Attorney General number 4. Yeah, that's one of the principles that was held in there. That the judiciary will determine when courts sit. And so, if you file it on the 5th of December, the proper thing, if I were for EC, is to immediately apply for abridgment of time. It will be heard. You yourself, the plaintiff, will be sought after. The court will make orders that publish it on radio. That the plaintiff and his lawyer should come to court maybe by 6 p.m. The court will sit 6, 7, 8, 9, 10 throughout, whatever it takes. But they can finish dealing with it according to law if they want to. But if that one fails, or they are not willing to do that, that's the type that sometimes you look at the rate, it's not proper law, but people will say, this action now, it will fail. So I will ignore it and go ahead. But that is not good law.
So that is not good law. You've made the point. That is not good law. If you fail the abridgment of time on the 6th of December, for instance, you're saying if somebody should do that, then it means you can't have an election based on your proper understanding of the law.
Yeah, yes, that's it. But and so I'm expecting that. Listen, this is basic. Listen, a competent lawyer knows that he has to go for abridgment. You can't. Then otherwise, the client will even sack you.
So in all of this, you say both Speaker and Executive Secretary of the President are right.
Absolutely.
They're just applying the law.
Absolutely, 130%. This one, you can't be wrong.
But you are also advising that if you had your own way, particularly the approval of ministers be delayed until the end of this government's tenure.
I tell you, Winston, that would be like a Christmas bonanza for me. Because Winston, it's nauseating. I can't believe that this is the president we voted for. So much hope. All the hope is being dashed. So much corruption, waste in the public sector. So much. I'm like, is this a dream? I can't wait for December 7th.
Let's hold on.
When I woke up this morning, I was like, so can there be abridgment of time for December 7th as well? I know it's in the Constitution, Article 60, Clause 13. It says when the president and the vice resign, within 3 months, we can have an election. Not that we can. We must have an election. So what the president can do for us with Baubia is that they just resign immediately. Let's have the election within 3 months. Because listen, they are suffering. They're suffering everywhere. There's so much despondency, so much anger, everything. It's like our democracy is just been thrown to the dogs. Why do we have to wait to December 7th when the Constitution is giving a very clear answer that president and vice resign? You must have the elections within 3 months. What are we waiting for? So, when the president himself expressly said it last year that, look, he can't do anything about the economy again, we should wait for the new leader. So why are we waiting when we can do it within 3 months?
So this is your prayer?
Yes. Let's have the election within 3 months because it's a waste of time. He himself said it to Winston. Have you seen that tape where he said
it was my colleague who asked the question. So I have listened. I have seen the video.
Yes. So let's play it. That Mr. President, you and Baumia just step down now.
Subsequently, he says he's in charge.
Oh no! That's an afterthought in law. It's a very lame afterthought. Look,
Martin, let's end it at this point. We'll continue with that conversation another day. Thank you very, very much, Martin Kpebu, for joining us this morning. Martin Kpebu is a private legal practitioner. I still have Kweku Asante here with me. So Kweku, that's it. Martin Kpebu says there's nothing that can be done about it. The Speaker is just following the law. The Executive Secretary to the President also following the law. Exactly.
I mean, the message you got was instructive. I think that there are those in Parliament and outside who hold a view that it will be problematic to hold that once an injunction application is filed, especially for state institutions, they are to stop acting. And in fact, the Speaker of Parliament makes that point, that if that is the principle that is supposed to be held now, then ultimately government business is going to suffer in the House, because as soon as anybody files an injunction application, he's going to put it on hold. He's not going, because of course the Speaker of Parliament disagrees completely with any view that Parliament can be injuncted in the performance of its lawful functions. So let's see how it goes, Winston.